Hello, everyone. It's Danny here. My sincere and genuine apologies for the delay in coming online. There's been a couple of technical glitches at our end, so I sincerely apologise for that. But nonetheless, we're here. We've overcome those problems, so let's get started and start talking about workplace issues and COVID-19. Because goodness knows, when you have such a large displacement of employees at any one time in history, there's always going to be workplace issues arising out of something like this. Over the course of the last 6 or so months now, there's been a couple of fairly significant changes to the way in which we manage and deal with our staff. It's also impacted COVID-19, obviously, in ways that are not related to our workplace. Some interesting statistics that I brought up, I thought that I'd start with, are that 57% of Australians have changed or cancelled their domestic travel plans. In March 2019, Australia issued 597,000 temporary visitor visas, and in April 2020 that number plunged to 195,000 temporary visitor visas. But relevantly for today, one of the big issues or changes that have occurred in the workplace has been that almost 1/4 of all employed Australians are working less because of COVID-19. Now, that reduction in 1/4 of Australia's workforce in terms of the hours that they're doing has not surprisingly resulted in a greater shift towards the casualisation of our workforce and or a move towards a workforce where reduced hours are now obviously working, but greater flexibility is expected in terms of both the way that employers manage their staff and employees, and how they work. One of the first things that we'll talk about today that I just wanted to touch on very briefly is the issues as they are in relation to Jobkeeper. Carolyn, if you could just move on to the next slide. As everyone probably knows, the Fair Work Act was amended earlier in the year to take into consideration the issues and workplace management scenarios arising out of the pandemic. I'm assuming everyone's pretty much up to date as to the changes that were implemented at the end of September, but just very briefly, I make these 2 points in relation to the Fair Work Act and the changes. Obviously, the first point there is fairly standard. Jobkeeper directions and agreements that were implemented after the 29th of, once the Jobkeeper enabling direction legislation had passed. And so long as the employer is still entitled to Jobkeeper, those directions and agreements are extending through to 29 March 2021. In relation to the second point there, 28 September 2020, an employer cannot request an employee to agree to take paid annual leave. I thought I'd put this in a bit of context because this is an issue that we found has been a little bit contentious, where there were or have been employees who are on reduced working hours or complete stand down and have been asked to or requested by their employer to take a period of annual leave during the period of their stand down. And one of the disputes that arose was in relation to a Ms. McCready and Village Roadshow, where essentially Village Roadshow asked Ms. McCready and every other employee that had more than 10 days of accrued leave to use their leave whilst they were stood down from work. The request in relation to Ms. McCready resulted in her effectively taking 1 day's paid annual leave per week. The way the law works or worked up until the 28th of September at least anyway, was that an employee could not unreasonably refuse such a request. One of the requests, or one of the refusals, or a number of, the refusals that Miss McCready used to object to the request that was made by Village Roadshow, and this obviously made its way into the Fair Work Commission, was that she had apparently had planned 5 holidays over the period September to July 2021, and therefore she wanted to retain her leave balance to be able to go on those holidays. Senior management should have been doing more of the heavy lifting to keep businesses operational, was another of her arguments for refusing to take the annual leave, or refusing the request to take annual leave. And also that the last point that she raised was that it was disadvantaged long-serving employees like Miss McCready. Now, fortunately, or unfortunately for Miss McCready, but fortunately for Village Roadshow, Commissioner Hunt concluded that that justification to take leave was not justifiable in either substance or in fact. Now, the reason I raise that is this particular point is because you'll see the note there that as of the 28th of September, an employer cannot request an employee to agree to take paid annual leave. And so any circumstances where an employee and employer still have this item or arrangement in place, arguably that arrangement should now come to an end, and any further request that an employer might make in relation to an employee taking paid annual leave, this test of the employee not unreasonably refusing that request no longer applies. And so it's just an important change that has arisen out of the changes that came into place at the end of September 2020. Moving on to the next slide, and I'm not going to touch too much more on any Jobkeeper issues. I wanted to really talk today about a number of points where I want to see and try and get people thinking about their current situation, and the points that I'll be talking about in relation to those topics that are on the slide now are more discussion points, and to get people thinking about what their current circumstances are and how they might deal with a number of issues moving forward. And the reason I say that is because only in the last 24 hours there's been a fairly important step taken by the Australian Council of Trade Unions in relation to, forecasting for us as employers and managers the types of issues that we might be confronted with between now and into the next foreseeable period of time. The issues that the ACTU have touched on only in the last 24 hours really deal with points 2 and 3, and I'll circle back around to them in a moment. But it's a really important, I think, shift or move that the trade union appear to be making, particularly for those employers who have employees capable of working from home, and in fact do ask those employees to work from home. It's not surprising to find out that obviously a significant part of the Australian workforce now is working from home, and that brings with it a whole range of challenges. But before I talk about points 2 and 3, the first point obviously there is a virtual workplace, and some important or interesting issues that I want to talk about today in relation to to this particular issue are those that are on the screen now. As we know, and as I've just mentioned, it's been regularly reported that a move to a virtual workforce certainly has been imposed enforced upon us. It's obviously required managers and supervisors to manage their teams in a virtual environment. And it also has meant that our teams working collaboratively have had to do so in a much different environment to perhaps what has traditionally been used as the phrase collaborative workforce and what we've been used to in the past. There was a report I read not so long ago that said that while many employees thrive in a less structured environment with minimal supervision, meaning that employees working from home there is certainly the capability and certainly a demonstration over the last several months that the less structured environment and minimal supervision has in fact allowed employees to flourish and become more productive than perhaps they were when they were closely monitored in the workplace. Yet others, types of employees and personalities require more frequent intervention. Now, there's nothing major or significant in relation to that particular point. You know, that's not an earth-shattering point. But when you think about that a little bit further, what it requires us as managers and supervisors to be cognizant of is that we need to, in many respects, better understand the personalities and the types of individuals that we're managing in the workplace to be able to increase or maintain a level of productivity that is acceptable to you within your businesses. And so as managers and supervisors, we need to think about how we might encourage individual flexibility to improve productivity or maintain a level of productivity, but at the same time develop our own interpersonal skills to make sure that we get the most out of our employees and the workers who are working for us. One of the interesting features that was in this report that I read related to the fact that those managers who perhaps in the past have been fairly heavy-handed in how they manage their employees, particularly on a day-to-day basis and in an environment where they're face-to-face, those managers and supervisors might be found wanting in terms of the results they get from their teams, and that it might be that some managers and supervisors that operate in that more traditional style of management may become obsolete over the course of the foreseeable future, and in fact they may find themselves wanting in terms of team performance. So it's an important and interesting characteristic and development that might occur over the course of the next short while. The next point there I've got is reinventing the physical workplace. So obviously under our work health and safety rules, we have a responsibility to ensure the safety of all of our staff at work, and that includes employees who work from home, because home is in many respects an extension of the workplace these days, and that's one of the key issues or central themes that have caused the union some concern. So I'll come back to that in a moment. But because of the greater number of people we have of employees working from home, the way that we see the physical workplace in offices is likely to change over the course of the next period of time, where people are increasingly working from home and employers are allowing employees to work from home in greater numbers. That the workplace itself may need to be considered to be something more than just a standard environment where you come in and sit at a desk and do your work. It might be that the workplaces of the future are little hubs, if you like, where people come together, they share ideas, they brainstorm particular issues or items that they're dealing with at the moment, and then they break away and head back into their cocoons to continue to do the work that's necessary. And so the workplace in the future might need to be cognizant of the fact that they are not a traditional place where people just simply turn up to work, but are more of I guess they have a social attendance function to the extent that employees come together, they work to develop and explore ideas and then break away back into their, as I said before, their cocoons. And one of the important issues associated with that is obviously, and should be encouraged, that social interaction, should employees need it, is to ensure that any of the side effects associated with an isolated workforce are reduced. So particularly those injuries and illnesses that arise from mental illnesses or injuries due to that isolation. And that moves us on certainly to the final point there about company culture and employee wellbeing. There was a paper that was released by the University of New South Wales earlier in the year, and it talked about 6 important ways that COVID-19 had changed the workplace for good. And what it talked about, particularly in relation to company culture, is that we as leaders and mentors and supervisors and managers need to ensure that we're doing things and challenging ourselves as leaders to make sure that the type of leadership style that we're adopting supports and improves or continues to harness the workplace culture that we want to have in a workplace beyond the traditional space where people come to or have traditionally come to on a 9-to-5 basis. Well, some of the in that report, some of the they identified essentially 4 key points that are important to understanding and challenging ourselves as leaders. And I thought it was useful to just quickly state what they were. It says clearly state values that will guide institutional actions, and these are all fairly self-explanatory points that have come out of this particular study. So the first one was clearly state values that guide your institution and your actions within your institution. Understand and openly discuss the hopes of the organisation. Communicate an ambitious vision of the direction of the unit or team that you're leading, and make sure that you demonstrate confidence that the strategic goals that you've identified the team can be achieved. And if anyone wants access to the paper, please let me know, because I'm happy to send it around after the webinar has finished. Moving on to the next slide. Thanks, Carolyn. And this is there's just some statistics. I forgot about that slide. There's some statistics there around productivity and remote work. As I said before, there's 25% of the workforce, well, that says more than 25% are working fewer hours. But work hours during COVID-19, the more interesting statistic there appears to be that, in my view at least, is that 55% of people are doing more hours than they perhaps would have done in the past. And this is where the ACTU have identified some real concerns, in that we've got this a seemingly more productive workforce that has arisen as a result of people being more isolated and in fact working from home. But the concern is that productivity isn't necessarily because people are more productive at home, but perhaps because they're doing more than their usual hours that they would ordinarily do at home. And there's a charter, well, I'll take a step back, sorry. Earlier in the year, the ACTU conducted an online survey of its members to work out and identify elements to put into a charter that would form the basis of the ACTU's focus moving forward over the course of the next over the course of the foreseeable future. And it's because of the fact that we have additional hours in the day, largely because we're at home and we're not commuting or whatever the case might be, that might be leading to the increase in productivity. And the ACTU have actually articulated that this is the next battleground that they're going to be confronting, is this working from home for employees. And what they want to do as part of this charter is start to improve or impress upon employers, either through collective bargaining, perhaps even through amendments through to applications to vary awards, but to improve the rights of employees who are working from home. And I think in any occupation where you have the capacity to work from home, this is a really important development that we all need to be mindful of. And I must say that the ACTU are not alone in their push for this, because the President, Ian Ross, President Ross of the Fair Work Commission, only in August released a draft variation or a draft schedule that the Commission is considering in relation to people from working at home. And so this is a really fast-moving, developing area of what we as managers and supervisors need to consider and have a handle on moving into the future. One of the three elements, if you like, that were at the forefront of the ACTU's charter was that working from home should be voluntary. So at no point into the future, unless of course because of third-party intervention like a government lockdown, working from home should be voluntary. There should be a right to disconnect to protect the work-life balance, and I'll come back to this right to disconnect because it's something that has a bit of worldwide momentum at the moment. And employers need to develop policies that avoid the prospect of work without end, and that might be driven partly by statistics like this that are on the screen at the moment that say that more hours are being worked in the day, and that may not necessarily be because people are being more productive, but obviously because there's more available time for employees to sit at home and undertake work in varying capacities throughout a day. The right to disconnect is in part, as I mentioned before, a worldwide phenomenon and is largely being driven by Europe. At the moment, Spain, Greece and Ireland all have legislation either pending or soon to be implemented that gives employees the right to disconnect. France, I don't know whether it's just because it's France or because they seem to do most things pretty well. Back in 2017, they in fact did implement legislation that gave employees the right to disconnect. And what that legislation essentially said is that an employee had a legal right not to answer emails, not to answer phones, not to have to do anything that that they might be asked to do by their employer once the workday ended. And if we need to understand and consider this, because this I guess it's not a development. This already implemented legislation in 2017 that talks about the right to disconnect. If France becomes the base model of how that right to disconnect continues to roll on throughout Europe and then into perhaps even the Australian working environment, we need to as employers start to consider how those items and issues can be managed. And that's not necessarily a bad thing. I mean, we need to obviously consider this issue of the right to disconnect in the context of our workplace health and safety obligations. And maybe in Australia, that's where the right to disconnect becomes a much more forceful issue because of our quite strict work health and safety laws that we have in place. But certainly the right to disconnect is gaining momentum within the trade union movement through the ACTU and, as I said, in Europe as well. And so we need to be mindful of what it might mean to give people the right to not do things that they might ordinarily do just because they're at home. And you know, you kind of think about that in the pre-COVID, you had a lot of, well, I know at least we did, employees checking emails and logging in to do things at night. Now, in many respects, people say that that's an expectation that comes along with the job, but at the same time, you've got to be mindful about making sure there's a demarcation between where the workday finishes and where your work life and where your home life commences. And with this whole working from home arrangement that's been very quickly imposed upon us, that blurred line certainly is, or that line is certainly becoming blurred. One of the, thanks, Karen. One of the second point there that I've got the case of the workers' desk. I thought I'd add this in as a bit of a case example in relation to how the Commission is dealing with certain working from home issues. And this is an employee who believed that he had no other option but to resign because the employer would not buy him a new desk, despite the fact that he had been forced to work from home. Now, I don't know whether this was a case of the unions supporting this fellow to push the envelope. It might be that that's the case. But in any event, it was unique to the extent that this employee was of the view, and it's obviously a constructive dismissal case where he's resigned on the back of obviously the employer saying to him, well, we're not actually going to buy you a new desk, and him saying, well, you created an unsafe work environment for me, so I've got no other option but to resign from work, and commenced a claim for unfair dismissal on the basis that he was constructively dismissed because of a course of conduct engaged in by the employer. Fortunately, Deputy President Coleman saw through perhaps what was happening here, and he concluded that certainly this particular individual was not forced to resign, and that the argument that he was forced to resign was entirely without merit, on the basis that the simple, and this is quoting Deputy President Coleman, the simple fact is that instead of resigning, he could have bought himself a desk. So one might think that just because an employee makes a demand and then that demand seemed to be fairly unreasonable, it doesn't necessarily mean that the employee has all the rights. And I thought Deputy President Coleman certainly put this individual back in their place. Moving on to the next slide, thanks, Carolyn, data collection. Now, this is another one of the ACTU's, one of their items that have formed part of their charter, which expects to be released over the coming days, is that because people are working from home and because of the technology that we use to monitor employees' performance and maybe even more closely monitor them because the employees are not in the office and you don't walk past and can see physically on their desk what they might be doing. Data collection is becoming an important focus for the trade union movement. And this, again, isn't just an Australian, something that's unique to Australia. There's a trade union called the UNI Global Union. Effectively, they're a worldwide trade union that cover employees in what they call as the skills and services sector. They released only recently a number of principles that they want imposed upon employers for managing a worker's data, in particular as it might relate to ensuring the privacy and protection of an employee's data and their right to privacy and a level of protection at home. And when you have, not that people are necessarily cognizant of the UNI and the Global Union and what they do, but they're a fairly large union to the extent that they've got 20 million workers operating across 150 countries around the world. So they are a force to be reckoned with and have a lot of political persuasion across the globe. And so it is, and if the ACTU, obviously the most significant union body in Australia, the fact that they've picked up on this as an issue means that, again, this is something that we need to be mindful of and be able to manage into the future. Essentially, the paper that was put out by the UNI, and again, I'm happy to distribute this if people would like it after the event, is the paper's focus is on securing workers and their unions' right to access, influence, edit, and delete data that's accumulated while an employee is at work. And you think about that, they want to seek rights as they might relate to access, influence, edit, and deletion of data collected at a workplace. Now, that is that's a fairly significant and broad charter that they've adopted there, and it's one that we need to be mindful of as employers, as I said, moving into the future. In Australia, employee data collection is mainly governed by the Fair Work Act and the regulations that deal with employee records and employee access to employee records. Anything that doesn't fit within the definition of an employee record, and that is a collection of data about an individual, obviously then falls within the confines of the Privacy Act. So you have this concurrent or dual set of laws that apply to how you manage employee data collection in the workplace. Assuming that the privacy legislation applies to your workplace, there are some limitations to it, not many, but some. Certainly there are some. And so as we continue, or as we're obliged to deal with some of these things, I think it's important, obviously, that we're aware of these principles as they relate to workers' data privacy and protection, and some of the recommendations that flow from the report that are of particular note. And there are ways and means with which we can, even in today's environment, start to plan for and start to be cognizant of and be ahead of how these issues might play out over the course of the next period of time. But the recommendations that certainly caught my attention was this principle of data minimisation, meaning that as an employer, we should only be collecting data for specific reasons and for justifiable reasons. So a haphazard, let's capture all data without explanation or justification is perhaps not a sensible or realistic pattern or behaviour set that we should, as employers, be adopting. We should all be starting to think ourselves around the data that we collect and the reason, and being able to justify the collection of that data in the event that we're ever challenged by an employee. Workers, one of the other principles coming out of this paper was that workers must have a full right of explanation when data is used. So when we're using the data that's collected in relation to an employee and their work functions, there's an expectation driven out of this paper that workers will have a full right of explanation as to when that data will be used. And you can think about that being important, particularly in the context of performance management or disciplinary issues, managing of ill or injured employees, where there is a fairly heavy reliance on data that's being collected about the individual at work, and without having a capacity to be able to fully explain to the individual before you collect that data when that data might be used, may in the future create some difficulty, and there are certain examples where that might even be a difficulty at the moment, but certainly not to the extent that's been explained in this paper that's been released. The third item that I thought was important was around the increased safety measures for protecting employee rights when the employer uses technology revealing an employee's location. So, as we know, certainly in motor vehicles, the GPS tracking of individuals has something that's been around for a period of time. I haven't heard or come across an employer who tracks a mobile phone that's given to an individual. So using the Where's My Phone app to make sure that they're cognizant or knowing where an employee might be at any one moment in time. But if that is certainly something that employers are doing, then this position paper talks about safety measures for protecting employees' rights when those technologies are used. And it talks about making sure, again, that you are transparent about when you'll be using it. You can fully explain why it is that you're using it and when, in fact, that data might be used in the future. So we're getting towards the end of my half hour. I again apologise. We had a technical issue, largely probably driven by my incompetence more so than the technology that we use. So I apologise for that. But I want to finish off with some important things to take away. Important to, even in this current environment, consider your culture in your workplace and how you might continue to develop, enhance that culture. Working from home appears to be the next battleground for trade unions, and making sure that there is a clear disconnect between when an employee is meant to be at work and when they're not at work, and even, in fact, giving rights to employees when they are working from home, and this right to disconnect. And just because these ideas are being driven by the union, firstly, doesn't mean that they're bad ideas. Secondly, it doesn't mean that you can't, in your own workplaces now, start to think about proactive policies that you could put in place to ensure that there is a demarcation between when an employee is meant to be at work and when they're not meant to be at work. And that can be driven, in many respects, ought to be driven by the health and safety of an individual when they are working from home. And finally, the collection of employee data, again, being mindful of the fact that there are movements both in Australia and globally around certain ideas about how the rights of an individual are perhaps going to be protected in the future, particularly around the collection of data of an individual. And again, not necessarily being negative about that, but being proactive in how you might start to deal with that now, and tweaks and changes to your workplaces so that in the future, when and if these changes are made, it's not a significant impact or imposition on your workforce because you've already been ahead of the game. So that's it for today. I can't see any questions. If anyone has any questions, do you want to quickly send them through now? Before I go, there was one question that I got around Jobmaker. People might recall we got Jobkeeper, Job Seeker, and Jobmaker. So the legislation that came in, and where there were significant subsidies introduced for hiring employees between the ages of 16 and 35, and whether it's legal to advertise a position for a Jobmaker eligible candidate. My response to that is that I think that there are some concerns around making a job advertisement that focuses on a person's age as opposed to their skills and abilities. And so if you, my thoughts are that you'd be recommended against actually advertising for someone who might be a Jobmaker eligible candidate, given that those people are generally between 16 and 35 years of age. All right. Carolyn, are there any questions that have come through? I can't see any. No? All right, team. Well, thank you everyone for attending. Please, if you want to get copies to any of the papers I've referred to today, just drop me an email and I'll certainly send them around. Thanks everyone and enjoy the afternoon. Bye.